was told here for 3 hours with nothing taking place. I think what should do, either prepare over the prison staff to produce people on time. The government is giving them fuel, they have vehicles. It is long ago when they used to walk. These days they have buses. They should bring people here at 9. What has said 9? And the state also they are here. So that we start on Monday.
The issue before you is not an institution. It is re-institution, the same charge. Those are two different English words. One is the opposite. To institute and to re-institute. These charges were instituted in Akawa court. They were dismissed. And after they were dismissed, now the very charges have been reinstituted before you. And the powers of the Constitution, Article 120, does not give the director powers to institute. It gives them powers to institute as he does that.
Political matter has been turned into a criminal matter.
I'm regretting why I fought for women to be debt-free.
Omuntu alina bendera oyina omuwa ekitiibwa.
Talina wadde P7. Piero yagitula 7:5 n'agwa, 7:6 n'agwa, ebyokusoma n'abinyuka.
Obulama nti nze mbadde nkula ekisanja kimu ne mpaako n'okwalala.
Bw'oba bakuba Lodimeyo olwoddawo.
Bobi Wine asobola okunkuba ambassador.
Kaakati omubaka bw'aba nga tantuuzangako myaka 5 nze ankiikirira wa ebirowoozo nga bijja wa.
Please send people who have competence. You can experiment on other things.
You're just choreographing something that is a rabasi kurukoko.
When we were last in court, 27 February 2026, for the trial magistrate, this case was adjourned today for ruling the prosecution's regulate the media in its coverage of these proceedings. Your Honor, unlike my colleagues who responded to the application for holding these hearings in camera, the hearing was for regulation of the media. Your Honor, we are ready to receive the ruling if it is before you.
Has given us to adjourn this matter to 27th of March. That's when she will deliver her ruling. So the matter is adjourned to 27th of March, the ruling and any other business.
Most of that
Concession is adjourned.
Stand with the truth. Stand with our leader. Stand with Uganda. Stand with Bobby Wine. Stand with NUP. We will everybody, because we will win. We are not criminals. We are not criminals. We are not criminals. Criminals are walking scot-free. We will win this war. People power.
Uganda versus White for Alex Mufumbiro.
This case is coming up for the state's response to the application by the accused through his lawyers. Your Honor, the application by the accused is that charge sheet is that this court makes a finding that the charge sheet be found incurably effective. Your Honor, and I will quote verbatim the objection by learned counsel Semuju Frank, and I quote, "I submit that the charge sheet and the charge are incurably effective in as far as it affects the accused person retrospectively." He went on and quoted, Your Honor, Article 28(7) of the 95 Constitution is to the effect that no person shall be charged with or convicted of a criminal offense founded on an act or an omission that did not, at the time it took place, constitute a criminal offense. He went on, the charge sheet and the accused was at Nakawa in criminal case number 0572 of 2025. The court discontinued the charge and set the accused free. Your Honor, if you allow me, he continues. It is now quite absurd that to have the same person appear in the same charge before another judicial officer in another court. I emphasize that he cannot be charged retrospectively. Your Honor, I've had the benefit of looking at.
Your Worship, if I may, to avoid the proceedings in vacuum and in error. Yes, court must have observed that actually by the time we made those submissions, our land colleague was in the court, and I think he was half briefed. The points of law were as follows. One,
Your Honor, I want to object to how my learned brother is proceeding.
It's on record that you made your submissions. It's now time for the state to respond. You will have an opportunity to complain. Why don't you let
Your
him
Worship, it is a
respond?
housekeeping issue because to avoid, because he has actually been complaining.
No, the court has a record.
Most of
And the court is the one that is going to make a ruling.
Most
Can we
of
know that?
Most of right.
Let state make his arguments. If you feel he has not covered all the objections, respond.
Most of right.
State, proceed.
Your Honor, my learned brother went ahead and quoted Article 28, 7. Your Honor, for avoidance of doubt, you allow me again to quote it verbatim. No person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not, at the time it took place, constitute a criminal offense. Your Honor, the charge sheet is very clear. Your Honor, the particulars there, read briefly, are that this offense, incitement to commit an offense, was committed on the 4th day of September 2025. Your Honor, the penal code is as old as 1957, if I recall very well, Your Honor. Your Honor, the offense with which the accused is charged has been in our law books, particularly Penal Code Act. Since then, and is still in the law books. Your Honor, so the argument that the charge was the accused brother was charged retrospectively is really misconceived. Your Honor, the ordinary meaning of the word retrospective is that the law, beg your pardon, that retrospective means looking back. Ordinarily, Your Honor, giving you the ordinary meaning of the word. Your Honor, I have established, unless my learned brothers will dispute that the penal code was not in effect as early as that. But we pray that the court actually overrules that objection. And in fact, we pray that the court confirms that the offense was committed as the charge sheet indicates. after the enactment of the Penal Code Act. Your Honor, I'm not sure what they intended to achieve, but this was, I hope, not a deliberate attempt to mislead the Honorable Court. Your Honor, on the issue of the council also submitted that that this was a disguised transfer or assignment of the charge sheet, and they say and they submitted that it was illegal. Your Honor, under Article 120, the Constitution, of the Republic of Uganda, Your Honor, it provides the functions of the Office of the Director of Public Prosecution. But also particularly Article 120, Sub-Article 3, B. Your Honor, if I may quote verbatim, functions of the Director of Public Prosecutions are the following, and B particularly to institute criminal proceedings against any person or authority in any court with competent jurisdiction other than the court martial. Your Honor, it was well within the powers of the Director of Public Prosecution, as enshrined under the article I've cited, that this case was registered in this honorable court, and the accused was invited to take plea. Your Honor, my learned brothers, counsel for the defense, called it a disguised transfer. Your Honor, I do not know what about it is disguised, as this charge was brought to this honorable court in the light of day. Your Honor, they submitted that the same charges had been dismissed at Nakawa Court. Your Honor, I left to wonder what a dismissal in one court has to do. Moreover, Your Honor, for the whole beg your pardon, Your Honor, the same charge, they went on to state that the prosecution was abusing the legal process. Your Honor, and no submission was made to address their skewed assertion. Your Honor, it is the provision of the Constitution that the Director of Public Prosecution at liberty to Your Honor, if I may invite this court to consider sections 85 and 88 of the Magistrates Court Act. Because at this point I am respectfully to my learned brothers, I guess they had not probably addressed their minds to sections 85 and 88 of the Magistrates Court Act. Your Honor, the invitation to dismiss the charge of being defective was not proper for the reasons that are found in these sections. And if you will allow me, Your Honor, to quote sections that I will pray this Honorable Court considers. Section 85, contents of a charge. Every charge shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. Your Honor, if you will be pleased, the charge sheet that was filed in this Honorable Court, it clearly indicated the statement of offense, that is incitement to commit an offense, contrary to section 21, subsection 1 of the Penal Code Act, Cap 128. Your Honor, the said charge sheet also had the particulars of the offense. And if you allow me, Your Honor, the pertinent Your Honor, in answer or in compliance with the section 85, the reasonable information that were included in the particulars that the accused may not be prejudiced, Your Honor, and that they should know why they were being charged, included the date on which the offense is said to have been committed, where the offense was committed, against whom the offense was committed, and the persons that were being invited to engage in this heinous charge that the accused is being rather alleged to have committed. Your Honor, it is our submission that these were sufficient and reasonable information, and it was in compliance with section 85 the Magistrates Court Act, Your Honor, we invite the court also consider Section 88, which provides for the rules of the Magistrates Court Act, which provides for the rules of framing of charges. Neither one of the about 15 rules were offended, and if there was any, Your Honor, the defense did not point out any of them. You know, the rules from A to R are very clear and self-explanatory. But if I may briefly indulge the court, A provides a count of charge shall commence with a statement of the offense charged, called the statement of offense. B, the statement of offense shall describe the offense shortly in ordinary language without necessarily stating all essential elements of the offense. It goes on and on and on. C, if I will briefly also quote C, after the statement of the offense, particulars of the offense shall be set out in ordinary language in which the use of technical terms shall not be necessary. Your Honor, none of these rules of framing charges was offended by the prosecution. It is our firm belief and submission that the accused was very well sufficiently aware of the charges that he faced, and respectfully, we believe that this was intended to waste court's time. Impressed upon court, or rather submitted, and in his own words, for several times, and I quote, I applied for bail and I was denied. I am innocent, and it will come to pass. But what is baffling is that when the matter was dismissed, I was brought to this court. Your Honor, he meant when it was dismissed in Nakawa, it was brought to this court. I am being abducted from different courts. Your Honor, he goes on, the state is in a fishing expedition where they throw me the court of their choice. Your Honor, it is on record that the charges in Nakawa Chief Magistrate Court were dismissed for the charge was being, rather for the reasons that the charge was defective. Your Honor, the accused was on a production warrant produced before this honorable court. Your Honor, and if I may recall, the officers may have been put on record that the accused deliberately disobeyed their lawful orders, that a protection warrant had been issued, and that was why he had been brought before this honorable court. Your Honor, but we find that to be an obiter in this application of the defense or the accused, that the charge was defective. But I thought it wise to address the same. The accused deliberately disobeyed orders, and as such, it cannot be said to be an abduction where the court, this honorable court, issued production warrant. Your Honor, no submissions were made on how charging the accused had the prosecution in abuse of the legal process. I've referred this honorable court to section 120, rather article 120 of the Constitution, which gives this honorable court, or rather the Director of Public Prosecution, powers to charge. Your Honor, maybe lastly, the defense or counsel for the accused also cited the case of Kasibante Moses versus Katongole Singh and another, which the court, Justice Chibuka Msoke, have said that the term jurisdiction is not a term of art, but a term of law and a term of very expensive legal import. Your Honor, it appears that their objection rotates around whether this court in fact had jurisdiction. Because if they are quoting case law and inviting the court to rely on the same, then let's have it. Your Honor, this court will submit has the jurisdiction to try the offense with which the accused is charged. Your Honor, the charge sheet is explicit that the offense was committed at Makerere Kavule, Wandegeya, within Kawempe Division. Your Honor, if I will also refer this honorable court to the magisterial areas instrument, Your Honor. The judicature Your Honor, that said, Kavule, Wandegeya, falls under this honorable court. Your Honor, my learned brother's counsel went on, and I find the rest really was obiter and of no, it would be a waste of time, Your Honor, if I responded to some of their Your Honor, the state, Well, I am really ashamed to reproduce some of these. I will leave it at that. We pray that this honorable court dismisses this objection as no valid reason was advanced support the objection, dismiss the charges, for which in their language was a disguised transfer and effective charge that was never supported by any submissions as to point out how defective the charge was. So
in a quick rejoinder to the reply by counsel for the state. Counsel for the state has alluded to the fact that the law within which the accused person was charged was amalgamated in the penal code way back in 1967. 57, I think you're pardon. And there is no injury caused while preferring charges against the accused. Your Honor, I will begin by defining retrospective. Your Honor, the Black Law Dictionary defines retrospective as legislation that looks backwards or context. As legislation that looks backwards. I is my daughter, that looks backwards or contemplates the past, affecting acts or facts that existed before the act came into effect. It essentially applies new legal consequences to events that occurred prior to the event. Your Honor, the Oxford English Dictionary defines retrospective as thinking backwards in regret. In my objection to the charges, I categorically stated that the accused person was once charged in Nyakawa Chief Magistrate Court with the offenses similar to the charges before you. The same were dismissed. I categorically stated that the charge sheet currently before you affects the accused person retrospectively. In my submission, Your Honor, I did not say that the law within which the accused was charged is retrospective. Because this is the law to be retrospective, it should either be repealed or revised or amended. I did not say that, Your Honor.
But what I said, Your Honor, was the effects, the omissions, the commissions of the prosecution, prosecuting the accused persons while taking him backwards. This is what I meant. Yes, Your Honor. To the charges that were dismissed, yet there is a remedy for that, which I'll allude to. Your Honor, when the charges were dismissed at Nakawa, allow me to read the last paragraph of his ruling at the Chief Magistrate's Court at Nakawa. The second last paragraph. It reads, therefore, the charge sheet remains unclear due to lack of proper particulars, which is a critical consideration while preferring the charges for purposes determining the jurisdiction. Your Honor, I would invite court to look at the provision of section 32 and 39 of the MCA. Your Honor, if you allow me, 32, 35, and 39 of the MCA. And I'll begin with the 32. Accused person to be sent to areas where offense committed. Where a person charged, where a person accused of having committed an offense within Uganda has escaped or is removed from the area within which the offense was committed, is found within another area, the magistrate's court within whose jurisdiction the person is found shall cause him or her to be brought before it, and shall, unless authorized to proceed in the case, send the person in custody to the court within whose jurisdiction the offense is alleged to have been committed, or require the person or give security for his or her surrender to that court, there to answer the charge and to be dealt with according to law. Your Honor, the magistrates at Nakawa, having found that the matter was not within its jurisdiction, decided to dismiss and did not prefer or did not send the charges to Kawempe. The law requires that once court establishes that court has no jurisdiction there, it causes it to be transferred to a court which has jurisdiction. Your Honor, let me jump to the areas, section 39 of the MCA. The High Court to decide the cases of doubt. Whenever any doubt arises as to the court by which any offense.
My learned brother, in rejoinder, should be restricted what I have raised. He is raising really new issues, and this is not proper. I invite the court, if anything, to expand his submissions. Your Honor, I have not, in my submissions, I have responded to only the issues they raised in their objection. Your Honor, he seems to bring up new issues in his rejoinder. I pray that he is called to order.
Counsel, what is your response?
Your Honor, Counsel for the State alluded to Section 88 and 85 of the MCA, which says that the rules requires on framing the charges. I'm using the same provision of the law.
You alluded to Section 88,
88.
you alluded to Section 32.
Most obliged, my lord.
Okay. But I think essentially in your response, the jurisdiction arose. So issues questioning why they were making their allegations to the submissions arose. It's only in order for him to respond.
Most obliged, Your Honor.
Proceed.
Your Honor, I was saying that High Court, Section 39 of the MCA, High Court will decide in cases of doubt. Where any doubt arises as to the court by which any offense should be tried, any court entertaining that doubt may, in its discretion, report the circumstances to the High Court, and the High Court shall decide by which court the offense shall be tried. Your Honor, when the Chief Magistrate's Court realized that it had nothing to do with the matter before it, it decided to dismiss it. And prosecution never moved the court. Take the same to High Court for determination, or decide which this jurisdiction it should be handled. Instead, Your Honor, it preferred fresh charges. I was about to say that the prosecution offended the principle of double jeopardy, but I will not, Your Honor, for the provisions.
And I will not write it. So proceed. Since you will not say it.
Must oblige, Your Honor. In summary, Your Honor, it's a trite law that court judgments are retrospective in nature. And the only remedy for any aggrieved party to challenge a court judgment, Your Honor, is either by going to a superior court for an appeal or seek for review of the same. None of the two was done by prosecution, Your Honor. This is the reason why I preferred the acts of the prosecution, charging the accused person retrospectively for the acts that were already concluded. And in a case of civil suit number 497 of 2018, civil suit number 497 of 2018, Mayanja, Joshua, and others versus Wantante, Samuel, and others. Lady Justice Florence Nakachwa. Cited with authority. The case of Philip Ayera, 1870, LR 6QB1. Saying retrospective laws are no doubt prima facie operational policy and contrary to the general principle that legislation by which the conduct of making is to be regulated ought, when introduced for the first time, to deal with future acts and ought not to change the character of past transactions. She further on her ruling at page 4, cited with authority the case of Wambeo versus Mazarele, miscellaneous application number 128 of 2013. where Justice Henry Kawesa stated that laws that govern legislation and statutory interpretation are to the effect that laws should never have retrospective applications and enforcement. Your Honor, the keyword here is enforcement. By charging the accused person on matters that were already decided. Is a clear retrospective application and enforcement onto the accused person. In the conclusion, Your Honor, I reiterate my earlier prayer that the charge and the charge sheet is incredibly defective and it should be dismissed. Your Honor, I'll invite my colleague to substantiate on the issue of.
Please, you want to go and send your notes. Your Honor, my colleagues have done a very good job. I don't intend to go over the issues that they have submitted. I just want to emphasize one critical issue because State has submitted severally disputing our assertion that this is a disguised transfer. We want to again refer him to our brand norm. Refer this court really. Article 28(9) of our country's constitution provides, allow me to read it verbatim, Your Honor. A person who shows that he or she has been tried by a competent court for a criminal offense and convicted or acquitted of that offense shall not be tried for the offense or for any other criminal offense for which he or she would have been convicted at the trial for that offense. Except, this is very imperative, Your Honor, except upon the order of a superior court in the course of appeal or review proceedings relating to the conviction or acquittal. Your Honor, what State had were two options: appeal or to seek for a review. State did not do that, and that's why we still assert that this was a disguised transfer, because the transfer did not happen. Your Honor, the accused person before you was presented in court, Nakawa Chief Magistrate's Court, formally charged. And then we came in to say the accused person is wrongly before this court. And we asked court to dismiss the matter. Your Honor, this accused person was acquitted by the Nakawa Chief Magistrate's Court.
What's it?
For all intents and purposes.
Was it an appeal?
You see, when you discharge, as far as we are concerned, because we were saying, we told court.
As far as you're concerned, as far as the law is concerned.
And that's the law I just quoted, Your Honor, Article 28. When you discharge, even to an ordinary person, the man was taken to court, and the court said, you don't have to be here, you are free. End of story. So as far as we are concerned, when he was discharged by court, what State should have done was to appeal or to seek for review. Because court did not transfer, Nakawa Chief Magistrate's Court did not transfer the matter here as is required by the law, Your Honor. That's our assertion, and we pray that this honorable court agrees with us.
You still want to
Just something small.
No, he attacked him on
He referred to me personally, and that is where
But he has legal representation.
I
Are you not supposed to talk to your lawyer?
Your worship, I have the right for it. Please.
And we didn't force that actually he will attack him in his
So are you saying
and,
your
and,
competence
and his
as far as
reply
you protect
and his reply was his reply. He had the audience reply the land friends, but he also had the audacity to choose me personally. And I'm grateful for your worship. And it is going to be very quick, your worship. Your worship, the state has clearly stated that I helped court. On the 12th, I helped court by telling it that I disobeyed orders, that I was broke. That is what he said.
I have not used that.
No, I don't need to use. I didn't say verbatim. So I'm not using your English. I'm using my English.
The beauty is that your submissions on the record.
Yeah. He insinuated that I assisted court in my submissions then, that I was actually brought here and I disobeyed orders. I want to start by telling him that actually I got an apology prison service for taking me on the tour without my consent. Because on that day, I left prison.
Your Honor, I object.
I left prison.
The record should be expanded. Your Honor, this is really taking the court on a merry-go-round. I pray that I understand as a lawyer, my learned friend.
In this matter,
that he does not really take this court to non-issues. If you will stick now, how is it going to help the court? Who apologized to you? How do we even know anyone apologized? Let's not waste court's time. I pray.
Your Honor, if I may, we are all guided by Article 28 Constitution, right to fair hearing. And the right to fair hearing does not only afford us as lawyers to speak on behalf of the accused. The accused may, at any point during proceedings, whisper or have something to say.
through the lawyer.
Yes, Your Honor, either through the lawyers or directed to you as a judicial for purposes of having the matter or questions in issue properly adjudicated. There is an issue counsel for the state alluded to, and the accused person has categorically had it and is trying to reply. Whatever language is using, it will be upon the court to assess and come up with a fair decision. I pray that let him be heard, whatever he says, so that he is duly satisfied. I so pray, Your Honor.
So this is satisfaction.
No, actually, your worship, it is for expanding his statement of disobedience. Because he alluded to my character.
Whatever state has said, wait a minute, let's go there. Whatever state has said in response to your lawyer's submissions, they have rejoined. So as far as I'm concerned, that is the material you need to make an examination. But as a suspect, I'll give you 1 minute to address this under Article 20. Proceed. And I'll put your record.
Your worship, I really want to confirm that on that day I was supposed to be in Nakawa. I obeyed and was taken to Nakawa by the prison service. On leaving Nakawa, I was toured around, brought here, without proof of a production warrant, without informing me. None was given to me, none was shown to me. And it would be wrong for anybody to come to court and say that I disobeyed orders. And it is a fact that the OC of the Upper Prison has apologized to me that they never informed me that I was supposed to be in this court. And that is what I wanted to be on the record, that they were also in error, because a suspect has the right to lawyers, A suspect also has right to information on what is happening to him. Me being domiciled in Lucida prison does not mean that the following day they take me to Karamoti without my knowledge. Even when they are transferring me as a prisoner, they inform me. It is my right. So it was an abuse of processes that they drove me around, and as I said then, I said today, it was on my insistence. And when it was due process, I am before you. And lastly, Your Worship, um, the issue before you is not on institution. It is re-institution, the same charge. Those are two English, different English words. One is locus to institute and to re-institute. These charges were instituted in Nakawa court. They were dismissed. And after they were dismissed, now the very charges have been reinstituted before you. And the powers of the Constitution, Article 120, does not give the director powers to institute. It gives them powers to institute as he has done. And that has been our point of contention, my point of contention. I believe this is an abuse of legal processes against the Constitution, Article 120, clause 5. It is an abuse of legal processes because it is the same office. That is why the other time it was a different person sitting there. Today it is a different person sitting there. It is the definition of the office, not the individuals. And that is what we are against.
Your Honor, before you take leave of the matter, you may be of the record.
You must be lucky first.
Really, Your Honor.
I think the state addressed me. Can we be orderly?
Your Honor, my landed brother, really, for them to call this a disguised transfer and all of that, he has just stated if they sought to do a constitutional petition, maybe I think that is what they have. These charge sheets have different numbers, they're totally different. Your Honor, we trust that you will look into our submissions against theirs and beg ruling on the same.
Yes, that was off record. Also blasted as it should have.
So many that I have not so in my procedures. It's only fair to me as well that I take time off to read through, appreciate the cases that you're submitting about their weakness, and then make a ruling that is reasonable, make a determination on your issue. So I'm going to adjourn this case.
Most of black
Your Worship, was able to use a mistake when that this court also pronounces itself on time. We are supposed to, court is supposed to be given by time. You tell us to come here at 9, we arrive here at 8, knowing the court is going to sit at 9. The court sits at 1. It's really not fair to all parties. I want to tell you that this court, people must collapse here because it was congested to maximum. People standing because they chased them out from outside, go to court, go to court. Now people stood here for 3 hours with nothing taking place. I think court should either prepare over the prison staff to produce people on time. The government is giving them fuel, they have veihicles. It is long ago when they used to walk. These days they have buses. They should bring people here at 9, if court has said 9. And the state also they are here, so that we start on Monday. Thank you.
I appreciate that. If you were here earlier, I think you noticed our sales system. We were waiting for this. The set was also. We were all walking around waiting for this. I will engage the prison authorities because I expected, particularly this case, to be handled at 9. They arrived towards 11, which was unfortunate, but I'm going to engage prison authorities to make sure they keep our time. It's unfortunate and we are sorry about that. But it's beyond our control because for us who are here, ready to start, we also have to wait for that. Sometimes they are limited because it's one thing for me to enter court and say, let's start. But like this is not here and he needs to be involved. So it was unfortunate today. And for the other instances that you face the same, usually it's we are going to engage them and they're going to, I hope. So allow me to adjourn this case to the 27th of March because that's more convenient. We have another case coming. So this case is adjourned to the 27th of March at 9:30 for ruling. If we have